Alrighty, good evening, everyone. Welcome to week 11 of administrative law. This is our final substantive week. Next week is revision for the unit as a whole. This is our final topic. We're going to be talking about remedies. It's a really important, something of a smaller topic, but a really important one because it ties together a lot of the things that we've been talking about all term. And we've spent now several weeks going through the grounds of review, going through thinking about, okay, how do we know that there's a problem with this decision? How do we actually articulate that problem in, one of the recognized grounds? How do we, formulate our argument to show that there's a problem? We've been through all that hard work. Now, what do we do about it? How do we actually, get some resolution to this issue? And that's a something of a tricky topic because, as we've sort of talked about in this unit, judicial review is limited. The court's role is constrained. They're not going to, make a new decision. This is not merits review. And so when we think about remedies, we only have so many options, and it's something that is worth discussing because it is important to know, one, there's not many options, but two, how do we use those few options that we do have really effectively? So that's what we'll sort of go through in a few discussion questions and then some hypotheticals this evening. Before we do that, a little bit of housekeeping. The first one being, I put a note about this on Moodle this morning, but just in case you didn't see that, there was a little hiccup with the quiz 5. I put the first question in and then it wouldn't let me actually add any other quiz questions. So you get things a little bit easy this time around. You only have the one question. Bit of a double-edged sword because it means that question is now worth 2 marks. So you want to get it right, but it's a pretty easy one. I started with an easy one and was going to build, but unfortunately it didn't work out that way. But it's the end of term. You've got other assessments and stuff. You've got all this revision for admin law to work through. So I figured you probably could do with a bit of an easier quiz this time around. So just the one quiz question. That means don't be fooled by the title question 1 of 4. There is only one question. And I think in the system, it will look like it's worth 1 mark out of 10. But then when that grade gets converted into gradebook, it should convert into the normal 2 marks anyway. I'll be keeping an eye on that just to be sure. But yeah, just the way the system hiccuped, it wouldn't let me do the editing I would normally do. So just to let you know that I'm aware that there's sort of stuff going on. I'll be staying on top of it, making sure that, you're getting all the marks that you deserve. But yeah, also, yeah, a little bonus as we get towards the end of the term for that one. Second bit of housekeeping, as I said last week, the end of term or what I called student evaluation surveys are open. My understanding is that you guys have got the red button in Moodle. I can't see the red button this time, so I've got no idea if those surveys are being filled out or not. Normally to encourage participation, I'll offer some exam hints for next week if we get enough participation. I'm going to, in good faith, just assume that there will be good participation and give you those hints next week anyway. But yeah, please do fill out those surveys. Your feedback is really valuable and really important. So if you do have, a spare, it only takes a couple of minutes. If you do have some spare time, please do make sure that you fill those surveys out. And once you fill them out, I think that the email team will stop harassing you as well. So you stop getting the emails. Yes.
Sorry, Jacob, we don't have the ability to do them. We've got the little one that pops up down the bottom, like the partway through evaluation of 1 to 10, but there's not actually like the evaluation we would do at the end of a semester that we've had before. And we haven't had an email to invite, I haven't had an email to invite me to do an evaluation yet.
Okay.
And I don't have it for any subject.
Interesting.
That's true, Jacob. I've just looked at my email. So there was an email sent out on the 17th of January at 4:25 p.m. saying to complete your unit and teaching evaluations, please click on your personal evaluation link. So it looks like there's been a change, because I don't have, you used to have the big red thing in Moodle up there and it's not there.
Okay. Excellent. Okay. So interesting. Conflicting reports about the red button. Some people have said that they've got it. Some people haven't. I was told that there wouldn't be one. I was told that the process now is sort of, as Michael was saying, you'll get an email with a link that will take you to complete those surveys. I guess I'll do some following up to see if those emails are being slowly rolled out. I would have thought that they would all be fairly automatic. But anyway, when you get the survey, if you get the survey link, please, I'd be really grateful if you do fill that out. Third little bit of housekeeping, as I mentioned, next week is going to be a revision week. We've got a practice exam question, and what I usually will do is I'll film, well, I have already filmed because it's from last term, as sort of a working through the practice question. I sort of use that as sort of talk you through kind of the first, it goes for about 40 minutes, talk you through the first 40 minutes of the exam. So showing you, things to be looking for, bits to pull out, and stuff like that. It's really designed to be I suppose, end point for your study. My recommendation is that you do all your revision, attempt the practice question yourself, and then watch the video, more as sort of a check for yourself that you're on the right track and that your study techniques are effective and things like that. I'm just saying that now in case anyone's kind of jumping ahead or anything, because I'll be releasing that video shortly. Relatedly, last week I said that I'd confirm whether there would be 3 or 4 questions. So I'll confirm that there are only going to be 3 questions. I'm not going to be asking about access to information this time around. So the practice exam question video that I'll upload, because it's from a previous term, does have that access stuff. So just disregard that. You can sort of jump ahead however many minutes. But everything else in there is good to go in terms of exam preparation. But yeah, just making sure that you're using that as effectively as you can. And my recommendation is that you'll get the most out of it if you don't watch that until you're fairly comfortable with where you're at with your revision. Excellent. The other thing about revision, if you've got any topics that you would like me to make sure that I really do cover in the revision week next week, please either let me know now or send me an email over the week. I will give sort of a broad overview of the unit, and I'll talk, especially what I try and do is talk about the relationships between weeks. So, how we layer different grounds of review together, how, issues of standing affect remedies and things like that. But if there's particular topics that you found, you really struggled with, or you would just like a little bit more discussion of, absolutely, please do let me know before then so I can make sure that I, cover that in a bit more detail. Excellent. That's all there was a fair bit of housekeeping that time around, but that's all the housekeeping we've got for today. Any quick questions before we get started? Excellent. So let's talk about remedies. And as I said, what's really important about remedies is thinking about, we're at the end of our sort of journey in reviewing a decision, and really we want to kind of get something out of this, right? We want some resolution to the issues that we've been having. And so there's a distinction between common law remedies and remedies under the Administrative Decisions Judicial Review Act. The distinction is very straightforward. If you're using grounds of review and, access to the judicial review in the first place via the Administrative Decisions Judicial Review Act, that's where your remedies come from. If you're accessing judicial review via common law, so for example, the Administrative Decision Judicial Review Act has been excluded for some reason, for example, the Migration Act, and you're going that common law route, your remedies are going to come from common law. The distinction is that simple, really. So just making sure at the outset that you're talking about the right kind of remedy. And the reason that that's relevant, and the reason why I think people get tripped up on that, is because fundamentally the outcome is the same, right? You can get an order setting aside the decision, or you can get a writ of certiorari, which quashes the decision. So in effect, the same thing, right? The decision is gone. You can get an order compelling the decision maker to make a decision. You can get an order, a writ of mandamus, compelling the decision maker to make a decision. So, the remedies themselves have very clear parallels. It's just a matter of making sure that you're using the right one. And, I'll leave it to your imagination, given that we've spent the past however many weeks talking about the Administrative Decisions Judicial Review Act. I will, you can guess whether I'm going to turn around at the last minute and say, actually, we're going common law for the exam. So, read into that what you will. Beyond that, though, I think it's really important to make sure that you spend enough time, especially in the exam, make sure you spend enough time talking about the detail of the remedy, what you're looking for, why that's useful, relevant, important, and maybe a quick discussion of what the implications of that might be. I'll talk about this next week, but for now I'm not going to put out so there's 3 questions. They're not all weighted equally, and for now I haven't exactly decided how many marks the remedy section is going to be worth, but last year it was worth 10 and I've cut out question 4, so it's probably going to be worth more than 10 marks. And so you have to think in the context of an exam, if you only write 2 or 3 sentences, can I really give you 10 marks for that, or more than 10 marks for that? Probably not. And one of the most common issues I see people running into in the exam is they don't spend enough time on the remedies. And it's hard to tell from a marking perspective whether that's just because they've, rushed and run out of time and have just had to quickly put anything in for the remedy, or whether they are just over it and just want to quickly get through that and move on, or they just sort of underestimate the section. It's hard to tell, but learn from previous terms. Don't sell yourself short on the remedy section. They're easy marks if you get it all right and talk through all the issues. But if you only doing 1 or 2 sentences, you're giving marks away at that point. So for your own sake, just don't write, as a remedy, the court should set the decision aside, the end. I would tell you right now, you need more than that. So being really specific on what particular, remedy you're after, what that does, what effect that will have. We'll talk about in a moment some of the sort of the reasons why relief might not be available. That might be relevant too. So really thinking through, there's more than just getting to the end and saying, so set the decision aside, please, the end. There's going to be more than that. So thinking about the specifics of the remedy and what it's going to do for you. Also think about the interactions between the different remedies and sort of how they build on one another. So a good example of this might be, let's say you had, and obviously the midterm assessment was merits review rather than judicial review, but let's say it was judicial review. We've got our client who has made this application. It's been rejected. There have been problems with it. We've gone through judicial review. Obviously, to start off with, we would like that decision set aside, right? So we're going to ask for an order setting the decision aside. But if we do that, then, and that's all we do, then our client is still at the end of the day left with no breeder's license, right? They've still not got the outcome that they were hoping for. So what you could do is also ask the court to send the issue back to the decision maker to remake the decision, right? And so at least having done that, we've now got the opportunity for the decision maker to make the decision again, and hopefully we get that license, right? So we've gone from, if you don't ask, if you don't send it back to the decision maker, there's a 0% chance that you'll get that license. If you ask, you at least have got a chance that they might still say no for whatever reason, but you at least have a chance. So thinking about how those two remedies work together and thinking about what your client's end goal actually is. The flip side of that is, don't automatically ask to set the decision aside and send it back down to remake the decision. If you had a scenario where, let's say you had a scenario where the decision maker has required you to, I'll use an old exam question. Let's say you had a decision maker who required you to go into hotel quarantine for 14 days. You would like that decision set aside, right, to get your client out of hotel quarantine. You don't necessarily want the decision maker getting a second bite of that apple, right? You don't want that being sent back to them where they get the chance to go, oh, yeah, I've thought about it a bit more, and actually I would like you to go back into the hotel quarantine. So thinking carefully about the actual outcome that you want out of this and recognizing the limitations of judicial review. You're not going to get a new decision from the court itself, but thinking about how you use the remedies to whether you want that decision remade or not, essentially, is an important way of thinking about how we can use these remedies in conjunction with one another. Equally, you might want especially if there was problems with procedural fairness and the way that the client was treated, say, you might want a declaration, declaring the client's, right to a hearing or something like that. So thinking about the way that end goal, what do you actually want to get out of this? And then how do you layer the remedies on top of each other to get as close as you can to actually getting that is a really useful thing. Having said all that, don't just ask for all the remedies. That's a really good way to sort of show that you don't quite know what you're talking about, just asking for all of them. It doesn't happen often. It's far more often people just do the one sentence thing, which is probably a worse problem. But yeah, don't just ask for all of them and leave it at that. Think really carefully about, okay, which ones are actually going to be useful here. I've got a few other comments and tips and exam hints that I'll raise as we work through the discussion questions. But were there any questions that anyone had at this point about anything that I've just said, basically? Cool. Alrighty. Let's press on. And we've got a few discussion questions to work through, and then we've got we'll revisit the hypothetical questions from previous weeks and think about what we should try and get out of those. But let's start with question 1. What are the common law judicial review remedies? What do they do, and how and when would you use them? I'll get the ball rolling, shall I? What about a writ of certiorari? I'm going to assume that no one just wanted to say that one because it's a tricky word, because it is. Writ of certiorari, what does that do?
Essentially quashes the decision or brings the matter before the court to quash or nullify the order or nullify the decision.
Yep, absolutely. So, the translation is to be made certain, and, we're effectively giving certainty by moving the decision into the court's jurisdiction and then quashing that decision. So we've got certainty because it's gone. Awesome. All righty. What about another one?
Yep, prohibition.
Yep. What's that?
To restrain the inferior court or decision maker from exceeding their powers, acting outside its jurisdiction, and prohibits further unlawful action and exercising power.
Yep, absolutely. So, we're using this to stop a decision being made or stop its decision being made in a particular way. So, it's these ones, it's a little bit tricky because the timing is, obviously a little bit difficult. But yeah, basically what we're looking at here is if we know that there's already problems with the way the decision is being made, we can sort of get in earlier and use that writ of prohibition to stop whatever the problem that's occurring, stop that happening or stop that from infecting the decision, basically. Awesome. All righty. What else?
Similar to an injunction, Jacob?
Yes. Well, yes. Yeah. The difference being injunction being a form of equitable relief, and therefore, on the one hand, I don't know how many of you have done equity, but equity itself being an area of law that is, let's say, more flexible, right? It's, we're a little bit less concerned about the formal requirements of things and more focused on, look, what's the fair thing? What's the just thing? What's the equitable thing to do in this situation? So an injunction is a little bit more flexible, but on the other hand, the writ of prohibition falling under the court's original jurisdiction means that it's more difficult to exclude. So there's, in effect, they're basically doing the same thing. The ways of accessing them, I suppose, are a little bit different, and sometimes one will be more powerful than the other. The other thing, I was going to talk about it later, but I may as well talk about it now. The other thing that is really great about injunctions, and especially interlocutory injunctions, is that you can get them much quicker. And so, thinking about, trying to get in and stop either the decision being made or stop the decision maker acting on the decision. So let's say the decision has already been made and now, let's say a decision has been made and a financial penalty has been imposed as part of that decision, right? I'm trying not to use a tax example because tax itself is kind of different, but let's say under the Civil Aviation Act, there was a financial penalty had been imposed. You might quickly swoop in and get an interlocutory injunction to prevent collection of that penalty, while the main judicial review goes ahead. So prohibition and injunction, certainly there's a lot of overlap, but there's also some interesting and useful differences as well. Great question though. Alrighty, couple more.
Mandating someone take an action that they're required under my interpretation statutory to make or do. However, if it's a decision that requires a discretion to be exercised, it won't necessarily be captured by that. You can't require someone to exercise discretion in a particular way. All you can do is require them to exercise their function or their role or carry out their task.
Yeah, absolutely. So, you can compel basically, and you'll commonly see it used with an order of certiorari quashing the decision, and then a writ of mandamus compelling the decision maker to remake the decision. And as Michael pointed out, absolutely, we sort of draw the line at not being able to force the decision maker to make the decision in a certain way, exercise discretion in a certain way. If they've got a choice between A or B, you can compel them to choose, but you can't compel them whether to choose A or B. Is a neat little example. One more common law remedy.
Habeas corpus.
Yep, absolutely.
Release a detainee from unlawful detention.
Yep, perfect. Made famous in the Magna Carta. It's it's as old as it gets, this one. But yeah, it's basically compelling the release of a detained person if they're being held unlawfully. All this sort of judicial review requirements apply in terms of the lack of process and things like that. But yeah, basically release a detained person, because very few Commonwealth, especially, authorities have the power to detain someone in the first place. And most of the ones that do are sort of federal police, and those themselves have the courts are quite reluctant to get involved in reviewing those decisions at the best of times. So it's not stunningly common, but especially in migration cases, that's where we tend to see it popping up a little bit more often. So it's a good one to know, even if it's not all that common. And then in terms of equitable relief, which is not quite common law, but also not contained necessarily, or not rising at the same time as the Administrative Decisions Judicial Review Act. We've got the injunctions, as we've talked about, and then we've got declarations, declaring someone's rights or interest in a particular matter. Awesome. All righty. So as I said before, the key thing with these common law remedies is to really think about when they apply, and recognizing if you're using the grounds of review under the Administrative Decisions Judicial Review Act, if you're accessing review via the Act, you're using the statutory, the Section 16 statutory remedies, which are very much parallels to those common law remedies, but just making sure that you're not crossing those over. Equitable remedies are kind of a little bit in the middle ground, in the sense that you could be using, especially that interlocutory injunction. You could have a review under the ADJR Act, and then be jumping in for an interlocutory remedy in the meantime, sort of separately. Or equally, you could be going the common law route and use that equitable relief as well. So equitable remedies have that, a bit more of that overlap, but making sure that you're thinking about the Act and the common law remedies as being very separate is important. Why can't the court substitute their own decision in judicial review?
Separation of powers. The decision is for the executive to make, and the judiciary can't exercise the executive power.
Yep, absolutely. It's a theme that, of course, has been cropping up right throughout this term, but I think it's useful to, I suppose, remind ourselves of that role when we think about remedies, just because we want to make sure that with the remedy, more than anything, we want to be really making sure that we're not asking the court to overstep its role. And I think that that's something that's important for you guys to think about in your exams as well. It doesn't happen all that often, but more often than I think it should. People asking the court to, find or make a particular decision, right? As a remedy, we would want the court to grant my client the license, or, make an order declaring that my client should get blah, whatever. Which of course the court doesn't want to do, right? For the reasons Michael said, it's an overstep of the separation of powers. It goes beyond what judicial review is all about. They will not take kindly to it. And so it is just really important for us to be thinking, we can ask them to set the decision aside. We can ask them to send that decision back to the decision maker. We can ask them to, declare that the client has certain rights, or that, certain factors are relevant, perhaps. That'd be pushing it, but we could ask for it. But we can't go that step further and ask, for the court to make that decision on its own. So that's, useful to keep in mind when you're thinking about remedies. I want you to be thinking about the end goal for the client and how we're going to try and get there. But you also need to recognize that the court can only go so far in helping with that at times. Question 3, under what circumstances will relief not be available? So, these are occasions where the court has discretion to refuse relief. And why are these exceptions, or why is this discretion important?
Were some of these, and I can't find the notes, so this is going back to listening to the lecture earlier, but today, where, for example, the court's of the view that the decision, if it was referred back, would simply be remade. That presumably the decision maker would address their issue and still arrive at the same conclusion. So it wouldn't really advance anyone in any respect, sending it back.
Yeah, absolutely. So if the decision will probably be imminently and lawfully remade, the court might decide, look, we're just going to save everyone's time and leave this as is. And it's a tricky one, because the whole point of arguing that there's a ground for review, that this judicial review should take place, is that there's been some error in the process that has invalidated the decision. And so we want to make sure that error isn't so trivial that that the decision maker can just easily fix that, and then the rest of the decision can just be made as normal. But it's a thing that does need to be taken into account. If the decision maker could quite easily just turn around and say, oh, okay, yep, I'll give you your procedural fairness. Here's 30 days to send me something that I'm not even going to read, and do it again, or whatever. It's something to take into account. Absolutely. What about some other discretions?
If merits review is available.
Yep, absolutely. So under section 10, subsection 2 of the Act, if there's a more appropriate remedy that's available, for example, through merits review, then the court will, give you, and here's the thing, right, is most of the time we would probably much rather be going to merits review ourselves anyway, right? Because merits review has that power to remake the decision. If merits review is available, we want to be using that process. So we shouldn't be finding ourselves in that situation anyway. But if we happen to, then yeah, the court could say, look, you've got merits review. We're really busy. Please do not waste our time. You go and see the AAT or the merits review body instead. Absolutely. A few more.
Something about unreasonable delay or failing to, I can't think of the exact words that would be there, but failing to raise at first instance the objection and then coming to it later, and may well create difficulties.
Yeah, absolutely. So these sort of fall under a broader umbrella category of sort of the conduct of the applicant. And so these, cover scenarios where the applicant has unduly delayed, failed to object at first instance, where they themselves have, done something misleading, or they themselves have not, gone about things in the right way, or where the court, is given evidence that really all the applicant is trying to do is gain like a business advantage. These are, factors that the court does not take kindly to. And so, they might choose to exercise their discretion not to grant relief, and therefore, be bothered with the case in general. So looking to the conduct of the applicant and it's not necessarily a hard and fast rule. If there's, it's undue delay, not delay. So if there's a good reason why the applicant has delayed, that's, there's flexibility there, but it is something to be thinking about, is looking at the conduct of the applicant in general. Have they gone about this in a way that is, I suppose, have they gone about it with integrity is probably the best way of describing it. And if they have, then probably everything will be fine. If there's issues, then the court might exercise its discretion. There's two more that we should talk about.
The nature of the administrative action.
Yep, absolutely. And, commonly we're thinking about the sort of decisions by the DPP to whether or not to prosecute or something like that. Basically, if these are decisions that what you tend to find is, you remember all the way back in week 4, we talked about the justiciability of an issue or of a decision. If there's a problem with justiciability, we might expect to have a problem with the nature of the decision at the remedy sort of end of the spectrum as well. These kinds of categories of decisions that the court doesn't really want to be involved in reviewing, they also, naturally are not too keen on trying to remedy either. So thinking about those as kind of bookend issues is a useful way of thinking about that as well. Awesome. One more.
Relief is futile or it will have no effect.
Yep, absolutely. So if the damage has been done, if the opportunity's been lost, the relief might be futile, and then the court will decide it's better to, save everyone's time and not get involved in the first place. And I think, a good example of this would be, just to keep bringing it up because it's recent and cool, the Djokovic case, right? He, after the full court made its decision, he was like, right, that's the end, got on the plane and left. If he then, having left, decided, actually, let's take a shot at an appeal to the High Court, the High Court might have been able to say, well, look, you're challenging this decision to exclude you from the country, and yet you've already left yourself. If we say, okay, you're allowed to be here, but you're already gone, there might be actually no point to that. By this time, the Australian Open's finished. It's all, the moment's passed. Why are we going to bother with this? So that's a good example of an occasion where relief might be futile and the court might choose to exercise its discretion. That segues really nicely into another point that I want to make about these sort of categories of issues in general, is that they're discretionary, right? The court has the discretion to refuse relief based on, these kind of issues. What is really important about that is that because there's discretion on the court's part, that means that there's room for argument. It's not necessarily a hard and fast thing. There is room for you to present a reason, even if one of these things popped up, there's room for you to make the case that, look, I acknowledge that the court does have discretion to refuse relief, but I would like you to not exercise that discretion in this instance for these reasons. So, to go back to that example, Djokovic could say, look, I have a lot of money. I can afford an express trip straight back to Australia the moment that this decision's made. I can be here in however many hours. It wouldn't be futile to allow me back into the country. And that would probably be a pretty good argument. And it would be a good one to ask the court not to exercise its discretion, even though there's that chance that relief might be futile. Similarly, if the decision, if there's reason to expect that the decision will be imminently and lawfully remade, you might say, look, absolutely, there's a chance that the decision maker will do that. We also don't know for sure, so we'd like to roll the dice. There might be, some value to the case in general in terms of, exploring an issue that hasn't really been tested before the court. What I'm saying is that these are certainly categories that you need to be aware of, but they're not immediately and automatically fatal to a judicial review, right? They're discretionary, and that means that you can present an argument as to why that discretion shouldn't be exercised. There's two reasons why I'm making a big deal of that. The first is, I've said to you that the remedies section is, worth a good chunk of marks. When you go through the content of remedies, yes, there's a few things to talk about, but there's only so many. It's reasonable, I would think, to think that one or more of these categories might pop up. There might be something in the facts that would make things look like relief would be futile, or that there was some misconduct or fault on the part of the applicant. And so it might be good to be aware of these things so that you've got you're equipped to have a discussion in the exam about those things and to make the argument that the discretion should or shouldn't be exercised. The second reason why I sort of am emphasizing this is that this was something that as a general rule across the midterm assessments, this was something that probably could have been improved. Thinking in particular about the AAT's discretion to hear AAT's discretion to entertain reviews where the decision related to environmental concerns or related to particular species. That wasn't an automatic thing. That was the AAT was given discretion whether to hear that or not. And so there was scope for an argument to be made that that discretion should be exercised. So, you know, that was something across the board that probably could have been done a little bit better. And so I'm pointing to this as being another area where there's discretion, there's scope for you to make the argument, and therefore, you know, it's something that you might want to think about preparing yourself to make an argument. Does that make sense?
I think this approach is one of the things that have helped me this term. One of the things I haven't got into my head until just recently was that scaffolding approach with the way you actually write your responses to these issues, that you've got to take it as a stepped approach and really make sure, okay, step one, this is what is this part of authority, step two, this part, and making sure that you do that to actually get to that finding, but also cover off everything of what should be in that finding. You don't make assumptions that, oh, well, this is in the Act, so it doesn't apply. And I think that's one of the things you keep bringing up is so critical for this end of term or this next exam.
Yep, absolutely. You know, and having done the midterm exam, having, you know, when you guys get to it, when you look at the practice exam that's been uploaded, you know, you know how I operate by now. I give you a lot of detail. It's a lot of information to process when you first open that document up, but all that detail is there to help you. Everything that's in there is a clue that is something that you should be talking about, or something that's relevant, or you know, is useful in some way. And yeah, it's going to be the same thing with the exam, right? There will be, and this is the thing, right? We'll talk a lot more about revision next week, but it doesn't hurt to have this stuff earlier. If you are prepared, you will notice all those clues, right? If you're not prepared, those clues just look like, oh, well, that was a bit of random useless information. So being as prepared as you can, and we'll talk next week about practicing identifying things and having little mental, I call them mental alarm bells, that should go off when you see a certain phrase or some particular wording pops up. It should immediately alert you to something being potentially relevant. And that's, yeah, absolutely. That's true of these remedies. It's true of everything that we've talked about before. Going through things really in, you know, very methodically, piece by piece, you know, that's the best way to go about approaching an administrative law problem, is just building on things slowly by slowly, and yeah, you'll pick it all up, or most of it at least. Absolutely. All righty. Any other questions before we push on? All righty. So we've got basically for question 4, what we're doing here is thinking about the different hypothetical questions that we've looked at over the past few weeks, and thinking about what remedies we'd be looking for. So given that we've not got too many minutes left, what I'm proposing to do is just sort of very briefly run through them. And they're reasonably similar, but I think I'll pull out a couple of things that will be useful in each. So thinking firstly about weeks 7 and 9. So this was poker and the casino where people brought the alcohol in, and there was the disciplinary action. Straight off the bat, what we'd like to do is under 16(1)(a), we'd be looking for to quash the decision to impose disciplinary action. So quashing the decision that the employees had to be terminated. Thinking what I said earlier about, there are times when you want the decision quashed and another one remade under 16(1)(b), and there are times when you just want the decision quashed and that's it, and then everything goes back to, normal, the status quo. This, I would suggest, is one of those times where we don't want the decision remade. We want to just go back to the status quo, because the status quo was poker getting to run the casino as normal. So I would suggest in this scenario, we're not looking at 16(1)(b), send the decision back to the decision maker. We're only after 16(1)(a) to quash the decision. You might, given that there were issues with natural justice and procedural fairness in terms of the way that the disciplinary action kind of unfolded, there might be scope under 16(1)(c) for a declaration of the rights of the parties, and in particular, the right to a hearing. You could say that. Equally, you might not bother because you're not wanting that decision remade. It might be useful to have, just as sort of a protective measure, a useful statement on the process under the Casino Act or whatever it was called. But it's what's most important is quashing the decision and not asking for it to be remade. We can contrast that with the scenario in weeks 8 and 10. This was John Qantas and his application to run the airline. So asked for the license, didn't get it. Here, what I'm suggesting to you is that under 16(1)(a), we'd quash the decision to reject his application, and then 16(1)(b), we'd refer the decision back to the decision maker to make again. What we could do, so you'll remember, hopefully, this was the scenario where we had some concerns about whether there were irrelevant considerations that had been taken into account and relevant considerations that were failed to be taken into account. We could ask, in sending the decision back to the decision maker, we could ask for them to take into account those relevant considerations. But if we were doing that in the answer, we'd want to make really clear that we understand where the limits of the court's powers are. We're not asking them to, effectively make the decision. We're just saying, look, these are pretty glaringly obvious things that should have been considered that weren't. Please, decision maker, make sure that you at least look at those when you make the decision again.
Jacob,
yeah.
Jacob, sorry, is that where the boundary is? I suppose in relation to that is subject to such direction. So it might be a direction to consider certain things, but it can't go as far as a direction to grant a license or a direction to withdraw the, because that is going into the decision maker's space. That's going into the executive. But it could be, is it wide enough to encompass, subject to a direction that the court would, direct that the decision maker have regard to this report or that report or submissions, or how, if we were going to, in our exam, make relevant submissions, would we just go as far as refer it back, or would we go as far as refer it back and additionally seek an order that the matter be referred back with directions including blah?
If it's done well and with a very clear understanding of the court's, as how far the court's willing to go, you could set the directions. So obviously, we don't want to be seen to be telling the court to make the decision itself. We also don't want to be going as far as the court setting so many directions that it effectively, tells the decision maker how to remake the decision. So we want to be making sure that we're leaving the decision maker enough scope and flexibility to consider, to make the decision themselves. So for example, with John Qantas, what we might do is we might direct the decision maker to look at the right hanger, right? Because that was a problem with the last one, was that they looked at the complete wrong hanger. So we might say, look, you have to look at the hanger that he's actually owns and that is included in his application. But the decision maker then still has the discretion to actually investigate that hanger themselves and decide whether that hanger is safe or not. And based on that, then they still have the discretion whether or not to grant the license or not. So telling them, look, you have to actually look at the proper hanger, that's probably fine. Saying you have to look at the proper hanger and you have to find that that's a safe hanger, we'd start to get worried about that. So yeah, just being quite clear about where those boundaries are.
In terms of just talking about that Qantas one, the airline one of the things we talked about last week was scaffolding everything into the grounds of law for bad faith. Now, how would that affect the way you move forward with your remedies, with what you're talking about now? Because the whole point of that was to say, well, the person who's making the decision at this point has acted in bad faith. So how could the court then refer it back to the decision, or back to that decision maker? Because that's how I understand with mandamus it would work. How would you approach that in terms of a response?
Very carefully.
Otherwise you could be finding that you're going through that cycle again of saying, well, no.
Yeah. It's probably, I mean, in reality, a department is probably big enough. If a court is willing to find that there has been bad faith on the part of an individual decision maker, they might be prepared to go as far as saying, we're sending it back to the decision maker in general, as in the department, but this individual decision maker shouldn't make the decision. It should be, maybe someone else within the department. If that's not possible, let's say, it's only a small department, or for whatever reason, it seems that the department as a whole is troubled by bad faith, the discretion the direction might simply just be to say, look, we're sending it back to you. We found bad faith last time. Can you please do things properly this time? And, then they will be very cautious, right? Because they don't want to overstep that boundary. And yeah, that's the hard thing, right? It's better to sort of fall short of the boundary than to cross it, if that makes sense, right? It's better to not ask too much. It's better to not push that limit than to be seen to be asking to effectively make the decision themselves, or direct how the decision would be made too much. Does that make sense?
Yeah, I think so.
So theoretically, then, if there was somewhere that would be where you would, if you, based on what you found, you thought your ground for judicial review, that might be where, if you're going to very cautiously make some submission around returning it to the decision maker, that the directions might be going to correcting the deficiency or the error or what gave rise to the grounds, maybe?
Yes.
Or is that just being careful not to go too far with that, of course?
Yeah. So, and yeah, it's a tricky thing. But yeah, the directions, as a general rule, the directions are there to make sure that whatever was a problem the first time around doesn't happen a second time around. And sometimes that will be possible, and sometimes it is just that little bit trickier. Excellent. All right. I'm sorry, I do have to call it there because I've got another class to run off and teach. If you've still got questions, please absolutely jump on Teams or email or Moodle or wherever, and I'll get back to you. But other than that, thanks everyone for coming along. See you next week for the revision week. Thanks very much. Bye.
Thanks, Jacob.